Good evening and welcome to this session of the live learning classes conducted by the Board of Studies of the Institute of Chartered Accountants of India. It's great to be here this evening with all of you, and some of you have already sent in your greetings. Okay, good. Just looking for any queries. So we have Sushil Kumar Barik with how are you? I'm pretty fine, as you can see. And okay, one more thing before we proceed quickly. We have very little time for a very lengthy topic. So I just do not have time for answering queries that are not connected with the topic on hand. So any administrative queries, any general queries, etc. Of course, I will also see to it that we go per the track, not a problem. But the suggestion is kindly go for any queries. Or my other suggestion, in case you have any general query that you want to ask, or like Mr. Srinivasan put that, you have not uploaded your audit and so whatever, keep it till the end. Around the last 15 minutes, you start putting that. So that even if I extend little 10 minutes, it will not eat into our lecture time. Okay? This is the humble suggestion. Thank you, Ms. Swati, for nice words to begin the session with. So we have a question from Mr. Srinivasan again, which says, can an adjourned AGM be held on national holiday? Is there any restriction on EGM to be held in national holiday? What is the difference between public holiday and national holiday? Sir, to answer your last question first, and as we move on, we have already covered all this topic. Mr. Srinivasan's query is on AGM as to when the AGM is to be held. So, see, basically, the AGM is to be held on a day which is not a national holiday. Please understand, that is not a national holiday. There is no difference between a public holiday and a national holiday. Basically, the word used is national holiday. In normal speech, we say public holiday, but technically it is called national holiday under the Negotiable Instruments Act, as announced by the central government, as I mentioned yesterday. So that is called a national holiday, means for the entire country. That is why it's called national holiday. Therefore, but state government, maybe it's called public holiday, but I don't know for sure. But this is the technical term for national holiday. So to answer your question on adjournment, I will not do that now. When we come to adjournment as a topic, this will be answered for you. So your question is, one question is remaining unanswered. Can an adjourned AGM be held on a national holiday? Not now. You will get the answer very shortly. Is there any restriction on EGM to be held in national holiday? No. For EGM, there is no such condition. As you remember, EGM, a board may, whenever it deems fit, call an EGM. So it can even be on a public holiday. It can even be on a, or to use your the correct word, national holiday. EGM can be on a national, can be in a national holiday, but generally it should be at a place within India. Even the condition of registered office is not there for EGM. And that CTV, city, town or village, not there. It can be anywhere, so long as it's in India. In the case of a wholly owned subsidiary of a company incorporated outside India, it can even be abroad. And for IFSC private company, it can be abroad. So to answer your third question, public holiday, national holiday, nothing great difference. Because you don't know the difference, nothing will happen in the exam. But if you want to write in the exam, please write the word national holiday and public holiday. Okay. Secondly, EGM can be held on a national holiday at even not during the business hours, at any place. Last question, whether an adjourned AGM can be held on a public or national holiday will not be answered now. Rather, I will answer it when I come to adjournment. When I teach adjournment as part of conduct of meeting, you will learn that. So at that time I'll teach you. Okay. So this is how it is. We've already seen this. Up to here we came. Now we move on to what I would like to call the business. Okay, the word business is used in the very technical term here. So the word business as your dictionary meaning, no. So for example, sometimes somebody says, mind your own business, no, not that business. Or, sir, he is in business, he is not in employment, he is in business. No, not that business. This business means
the matter or agenda to be transacted at the meeting. What is the business means? What are we going to do at the meeting? What are the matters or agenda? Agenda means a list of items to be done. Agenda means a list of items to be done, like a to-do list. So, at a meeting, we should be clear about the agenda. Normal corporate meetings also have agenda. If you are a chairperson of a corporate meeting, it would be good to have agenda. 1, 2, 3, 4, and then the chairman will take the meeting agenda item by item. That is correct. Instead of just coming meeting, okay, let us talk. No, should be. So first item of agenda, second, and we should not skip the item of agenda and run. So the same thing applies to companies, but here the agenda is very, very strict. Please understand one thing. At the general meeting, no new item of agenda can be taken up. For example, if the notice has 4 items of agenda, you can only do 4 items of agenda. No, suddenly one member cannot stand up and say, Chairman, I want to take up this matter. No, sorry. In a board meeting, it can be done. Though it is not a good practice, still in board notice, in the notice of board meeting, last item of agenda would be any other matter with the permission of the chairman. Any other matter with the permission of the chairperson. But in an AGM or EGM general meeting, any business agenda item, you cannot take up an item unless it is mentioned in the notice. Okay. Suppose some member wants to take up something other than what is there in the agenda, there is a provision for that. They can put up other resolutions, but there is a strict procedure for that. We will see that later. Just like they will requisition a meeting, they can requisition an item also. Requisition a resolution also. They can. But for that, they have to send advanced information. That procedure will be discussed separately. There's a provision for that. So, business means matters or agenda to be transacted at the meeting. So, what is mentioned in the agenda only can be taken up. Very, very important. For general meetings, no new item can be taken up unless prior notice is given in accordance with the act. Okay, so business is clear. Now, there are 2 types of business. 2 types of business. Ordinary business, special business. Okay. Now, see, some of you are asking questions that are ahead of the topic. Kindly don't do that. Chairman will be covered in a short while. Any question should come only from a topic already covered. So, I mentioned chairman, don't please ask. When the topic comes, it will be taught. So, don't interrupt me, Marin Khan. Your question will be answered. Don't worry. It will be answered. Chairperson will be answered. Should be a member or not, will be answered. Don't worry. Similarly, Srinivasan's question will be answered. These topics are going to come. So concentrate on. So problem with this topic is some technical terms will be used which are necessary to explain one topic. So don't go there. Concentrate on the topic being taught now. Otherwise, you will only forget. See, in your eagerness to know something, you are not learning ordinary business, which is important. So, the word ordinary is what is it? It's ordinary man, not something which is surprising, which is done which is always done ordinary. So certain things which are done at the AGM are ordinary. Okay, so at the AGM, these 4 matters are ordinary business. That's all. 4 matters, easy to remember. The consideration of financial statements and the report of the board of directors and auditors. At an AGM, this matter, if it is taken up at an AGM, suppose you are approving the accounts at an EGM, it is not ordinary business. It is special business. So at an AGM, if you are considering the financial statements, report of board of directors and auditors, ordinary business. Declaration of any dividend, ordinary business. Because every year, say, हर साल का काम है ना, every year we'll do it now. So declaration of any dividend, then appointment of directors in the place of those retiring. Now this is something you will study when you come to final. How directors will retire by rotation. This will happen only at the AGM. Those directors who are retiring will be either reappointed or appointed. That matter, when directors are retiring and they are reappointed under the law, that matter is a ordinary business. At the AGM. Lastly, very important item of agenda was appointment of and the fixing of remuneration of the auditors. So this is very, very important item and very, very ordinary, but for me, very, very extraordinary. Am I correct? For us auditor, my reappointment is ordinary business. Means every 5 years I'm going to reappoint him. It's going to happen every 6th year. It's going to happen. Am I correct? Now it is not every year. It's going to happen every 6th year. Every 6th year. So he'll hold office for 5 years. 6th year, either he will be reappointed or some other person will be appointed. Right? Even whatever, whether you are reappointing the existing auditor or appointing a new auditor, if it is done at the AGM, it is an ordinary business. Okay? That's it. That's all. 4 matters, ordinary business. All other business at an AGM. So at the same AGM, suppose you're having some other agenda item, special business. There is no need to ask, sir, is it ordinary or anything other than these 4 at an AGM? Special. All business at any other meeting. So the minute you say it is not an AGM, anything that is transacted is special. Even if these 4 items come in an EGM, it is special. Okay. One more thing. In an earlier class, one student had this, Mr. Lokesh, I don't know why you are again and again pressing enter and creating blanks. Please do not do that. If you have asked a question, it will be taken up. Don't worry. You have just entered 6666. I don't know what you are trying to do here. Please don't do it. Whatever you are doing, do not to do it. Whatever you are doing, no, don't do it. That itself will be enough for me. Mansi, welcome. Now, all other business at an AGM. So earlier, one lady or gentleman had this doubt. Sir, all special business means special resolution, sir. No. Don't confuse your mind like that. Special business, alag, special resolution, alag. How do I know if it is special resolution or not? For that, you should be aware of the act. In the law, in the section, if it will very clearly mention, the law will very clearly say ordinary, special, resolution. So wherever it says special resolution, it is a special resolution. Where it is simply says resolution, please understand, ordinary resolution need not be mentioned. Suppose the section says the members, the matter shall be done by approval of members by a resolution, ordinary. Because if they want a special resolution, then they should mention special. If nothing is mentioned, just business, resolution, year resolution, then it is ordinary resolution. Okay? Because special resolution is special. They have, if they want, they should tell. If they have not mentioned, then boss, it is not special means it's only ordinary. So you understand? So if it is not a special business, ordinary business. Okay. But both special and ordinary will be defined later. Right? So do not make that conclusion that all special business is special resolution. No. Right? But to my knowledge, all special resolutions are special business only. Because, see, these 4 matters only are ordinary business. Right, sir? Consideration of financial statement, etc. It is always ordinary resolution. Declaration of dividend, ordinary resolution. Appointment of directors in place of those retiring, ordinary resolution. Appointment and fixing at the AGM, it is always an ordinary resolution. Only when you are removing him, etc., it will be a special, which will not happen as ordinary business. It will not happen as ordinary business. So these 4 matters are always ordinary resolution, which means special resolution will only be special business. But all special business need not be special resolution. I'm just not trying to confuse you, but trying to help you. All special resolution will be special business. But all special business need not be special resolution. There could be something which is mentioned as ordinary resolution also. But if it is not done at an AGM or not one of these 4 matters, then it is a special business. Okay. Why is special business so special? Because whenever you are transacting special business, you have to mention certain additional information. As the name implies, ordinary business is routine and needs no explanation. Okay. To declare a dividend, directors need not say, every year we declare dividend. Hey, how much, man, you tell? So not a resolution. But some other item. Suppose you are taking an approval from the shareholders for borrowing in excess of paid up capital and free reserves. Later on, you study. When you come to final, you study 180, 1C and all. So they are going to borrow in excess of. No, the shareholder doesn't understand. What are you doing? I want to know some more details. So the law says any special business, there should be a statement setting out the material facts. Material means important. In English, the same word will have many, many meanings. So in costing, you might have studied material cost. That is material. Means anything with which some product is manufactured. This is raw material. Whereas here, material means essential, important, not to be missed out. So material, sometimes you say a material defect, meaning not defect in material, material defect. That means a defect that is very, very so fundamental that it is going to the root of the matter. So that is called material. So the material facts concerning each item of special business to be transacted at a general meeting should be annexed to the notice. So this is very, very important. Yeah. Lokesh ji, I understood your key is not working properly. I'm absolutely no problem. I just wanted to alert you that this is happening. Sir, in case of EGM, both businesses are there. Then she, how? It is not possible now because these four are done only at an AGM. If these four are done only, any other business at any other AGM will always be special business. In an EGM, you will never have ordinary business. In case of EGM, there will be no ordinary business. Ordinary business will be there only at AGM. That too, only these four matters. Even any other business at an AGM is a special business. Have you understood, Ms. Saxena? Clear? Confirm to me that you have understood. So simple. Yeah, EGM means straight away special business, madam. AGM, these four matters are ordinary. Everything else is special. That is all. Okay. If it is special resolution, straight away I'm telling you it is special business. You don't have to wait. But ordinary business also will be special business if it is done at EGM, etc. What are the matters to be included? Mainly, the shareholders should be told whether any director or key managerial personnel or their relative is interested in the matter. Interested means financially interested. In case this matter is done, in case this transaction is done, will that director or his relative or manager or KMP get any financial benefit? So that in those cases, you have to clearly mention the nature of the concern or interest, financial or otherwise. For example, the approval is going to be given for a contract in a related party, with a related party. Got it? So this is a contract with a related party. For that, we are going to the members for passing a special resolution as per the law. So in that case, you have to mention very clearly that this being a matter of thing, that the contract is to be entered into with a firm in which the wife of the managing director is the partner. So the nature of the concern or interest should be told. Okay. Any other information and facts that may enable members to understand the meaning, scope, and implications of the items of business. Okay. So writing this note is very, very important. Outright. In your case, you don't have to learn because in the exam, they won't test you on that. Company secretaries, they should know how to write this material facts. Because you should not leave out anything, but you should not tell anything unnecessary also. So you should clearly mention that we are going to enter into a contract for supply of chemical so-and-so from so-and-so firm. This is a firm in which the wife of Mr. So-and-so, Mrs. So-and-so, who is the wife of Mr. So-and-so, is a partner. The supply is being made with prices which are arm's length. Or normally, if it's arm's length, you won't even need a special resolution. You can say the supply is being made at the following price, which is higher than the arm's length price. This is because, we'll give some justification for that. This is because the quality is better, or they are performing some additional services which is included in the price. Some explanation should be given so that the members will clearly know why they should approve the transaction. Please note, in case any material fact is concealed and the member's consent is obtained, tomorrow it might become a problem for the directors and the KMP. So
The principle is that the members should be enabled to take an informed decision. See, suppose I am asking you to give me a consent for a matter, then I should very clearly tell you what it is now. Sir, what are you trying to do here, sir? You tell me what will be the impact, what will be a possible outgo, whatever. So you have to tell. Yeah, just to quickly answer the question, yes, I am a member of the Institute of Company Secretaries also. I qualified in 1991. I'm an All India rank holder in intermediate and final. 4th rank in intermediate, 10th rank in final ACS. Okay. I'm also a faculty for that institute. Okay, now, where any item of special business to be transacted at a meeting relates to or affects any other company, the extent of shareholding interest in that company of every promoter, director, manager, KMP of the first mentioned, if the extent of such shareholding is not less than 2% of the paid up share capital, should also be set out. So this is in addition to disclosure of interest. So you should also say so-and-so private company in which the wife of MD is a director. In addition to that, if the MD or any director, manager or KMP is holding shares in that company not less than 2%, that should also be disclosed clearly. Got it? So this is purely disclosure. So say they are holding 50% or 25% there, like that. You should mention. So the idea is the shareholders know that this is a related party. Suppose the matter is one where nobody is interested, then you have to write one line. No director of the company is interested in the transaction. That's all. One line. Everything over. No director, manager. If there's no manager, don't have to bother. No director or key managerial personnel of the company is interested in the matter. That's all. Simple. But you have to mention that nobody is interested. You cannot simply leave it blank. Okay. Where any item of business refers to any document. For example, we said a contract is to be entered into between this company and the firm. Then that document can be inspected by the members. So the time and place where the document can be inspected should also be specified. Why? Because a member has the right. Baba hits his money, so he can come and see whether the terms and conditions are favorable or not. So this is the point. Okay, thank you for kind words. All that happened long ago, 1991. Okay, now the effect of non-disclosure. See, if you keep quiet, sometimes keeping quiet is also a crime. So by not mentioning it, silence will also be a danger. So in case the disclosure is not made, and it continues. See, I told you one example now. We are entering into a contract with a firm. A Limited is entering into a contract with AB and Co. Now, Mrs. A is a partner there with other people. A is the MD here. So there is an interest. Now, the price at which the firm is selling the chemical is 4 rupees more than the market. 4 rupees more, for which we are saying there is some services, for example, they are purifying it or maybe packing it or something we are saying. But if we don't mention it, we don't mention anything. We don't disclose the fact that that firm is one in which the director is interested and the members approve it. What happens? That entire year chemical is supplied now. Let us say 1,000 liters or 2,000 liters into 4. That is the benefit now. 4,000 rupees is the benefit. That benefit which may accrue to a promoter because there is over and above the arm's length price. Let us say that the arm's length price is only 30 rupees. No, we are buying it from them at 34 rupees. So that 4 rupees, why am I paying? I can as well buy it from the market now. Mandi may have 30 rupees. Why am I buying it from these people at 34? So they might say that extra benefit, okay, as a result of non-disclosure, then if that benefit is there, then such person will hold that benefit in trust for the company. Okay, and he has to refund it. He has to compensate it. This is in addition to penalty. In addition to penalty, there is a penalty for non-compliance with Section 102. In addition to the penalty, that person also will be liable to whatever extra profit he has made, benefit.
will have to be held in trust, meaning he is not the owner. He is only holding it and he has to give it without prejudice to any other action being taken against him. Means in addition to, whenever you see the words without prejudice, immediately remember, if you see this word without prejudice, remember, it means in addition to. Just you can substitute the word. Suppose you say, sir, I don't like without prejudice, blah, blah. What to do? Simply substitute. In addition to any other action being taken against him for the time being enforced, be liable to compensate. So in addition to, without prejudice means in addition to. So don't go into the meaning of without prejudice. And that is, I don't want to explain also. It's very difficult to see. Once you know what is without prejudice, you will know. To explain it, it's very difficult. It's a very old way of speaking English, legal way of speaking English. If you think, no, sir, it's boring, I don't know how to do that, don't. But in the act, it says without prejudice. But when you're writing the answer, you can say, in addition to any other action being taken against him, in addition to other penal liability, he will also be liable to compensate the company to the extent of the benefit received by him. So remember, without prejudice means in addition to. Penalty is there. In addition to that, he has to compensate the company. So this is the penalty. Every promoter, director, etc. will be liable to a penalty of 50,000 or 5 times the amount of benefit accruing. So benefit will also be refunded to the company, plus the government will take 5 times the benefit. 50 or 5 times the benefit, whichever is higher. So if the benefit is only 5,000 rupees, you'll have to pay 50,000 to the government and pay 5,000 to the company. Okay. Again, this is without prejudice to the duty to compensate the company. Meaning, this is in addition to compensating the company. Okay. Good. So now we move on to another interesting topic, which is quorum. See, carom is a indoor games. You might have played carom. This is not carom. Why I'm saying now, once when I was correcting the papers for the ACS, now, not the exam papers, the CC paper. No, I used to conduct the CC, the Quorum coaching class, when they will write the CC test, weekly test, we'll set. So where they will write, one boy is writing carom, C-A-R-R-O-M, carom, for quorum. Q-U-O-R-U-M, quorum. Quorum means the minimum number of persons required to constitute and transact business at a meeting. So that is why first you should give notice to convene. Then you should see to it that business is correctly mentioned in the notice. Notice goes to that gentleman or lady. Then the meeting has to start now. So for the meeting to be validly conducted, to be properly constituted, there should be a minimum number of persons. That minimum number is called quorum. For example, if you have a residential welfare association, just check out. Suppose you are living in a complex of residential apartments. Then definitely there will be a residential welfare association or something, society or something. Maybe if you are just out of interest, you go to the guy who's secretary of that association and ask him, sir, can I have a look at the bylaw? Because all association will have bylaws. Bylaw is nothing but articles. Bylaw is nothing but articles. Articles are the bylaws of the company. So this association, which should be registered in the Mumbai Societies Registration Act, would have a bylaw. That bylaw will also mention the meetings of the members will be held once in every year. Other meetings can be held like EGM whenever they want. The quorum for a meeting of the members of the association shall be, they would have fixed a quorum, 10 members, whatever. I don't know. Each, they would have fixed it. Here, the law fixes the quorum. The Companies Act says the quorum for general meetings of a public company, okay, shall be the following. But here they have linked it with the number of members. In those days, whatever may be the type of company, the quorum was 5 members per single person. Now what they are saying, up to 1,000, not more than 1,000. Up to 1,000. The company has 1,000 members. Then on the date of meeting, the company has 1,000 members. Then 5 members personally present. Personally present, you have to understand. A member may be present in 2 ways. One, personally. That means he attends in person, physically. Secondly, through proxy, meaning he is attending not personally, through a representative called proxy. So don't think that when proxy is attending, member is not attending. member is attending through proxy. In other words, member is present through proxy. Please don't make the mistake of saying, sir, member has not come, only proxy has come. No, proxy represents the member. So the member is attending through proxy. So are you able to understand? One of the important right of the member at the meeting is not to eat jalebi, but to vote. Many members come only for, in those days, listed companies, at the AGM, they used to give sweet box. Fellows will come only for sweet box. Nowadays, they are prohibited by SEBI. Listed companies are prohibited by SEBI to give any gift or any sweet box, etc. But in those days, they'll come, they won't even attend. They'll simply stand in the queue for the sweet box, take the sweet box and run. Okay, so that is not the duty of a member and a right. It is his duty and right to vote. Now, that right to vote on a poll is available to the proxy. So, again, to repeat, members can attend in person or through proxy. Got it? But for quorum, we have to count only those members who are personally present. So, if proxies are there, we will say, my dear proxies, just move aside. Now we will count. How many are there? Company has 1,000 members. 5 fellows are there, personally present. Quorum hai. Chairman can proceed with the meeting. Suppose the company's membership is more than 1,000. That is 1,001 up to 5,000. Then you need 15 members personally present. Again, everybody will be crowded around. You announce in the mic. All the proxies kindly be seated in the left-hand side of the hall. Yeah. Now only those who are personally present. But usually what we'll do now, we'll have a separate attendance register for personally present and for proxy. So that once the personally present number is reached, now we will have attendance register. Now that is enough. He is signing and then only coming inside. So he is attending. So in large meetings, I will show you one. Thing. I'll just show you one second. See, just interesting thing. I thought I will show you. This is during the pandemic. Reliance meeting. This is the meeting of Reliance. And mind you, this is only the physical meeting. This meeting was a virtual meeting. During the pandemic, Reliance conducted what was known as a virtual meeting. This is Mr. Mukesh Ambani speaking to them. Now, this was a pandemic period, so there was a restriction. And in addition to that, this whole meeting was being telecast virtually, and members were attending from across the country and world, listening to Mukeshji on virtual platform. Plus, e-voting was done, electronic voting was done. Just for information, just to show you that how an EGM or AGM of a company will look. It looks almost like a concert, no? And remember, this is during pandemic. Before that, when Dhirubhai Ambani was there, Reliance meeting, before all this no gift and all that, Reliance used to give a coupon for buying they had that Maharati shows. So they used to give coupon for buying, discount coupon and also. There will be a huge crowd. They had to conduct the AGM, you're not going to believe this, at the football stadium in Bombay. Okay? That was the concept. So just I wanted to show this to you so that you will understand how it is. So that's what I said. So up to 1,005, 1,001 to 5,015, 5,001 and above, 30 members personally present. Okay. For a private company, 2 members personally present, because a private company can have only 2. So however, maybe how many ever members, and you all very well know there is an upper limit on the number of members of a private company. What is upper limit? Anybody can tell me? Anybody remembers? What is the maximum number of members of a private company? Maximum number of members, not including in past and present employees, blah, blah, all that. What is that ceiling number? I just want to know if any of you remember. I don't. That's why I'm asking you. You'll have to refresh my memory. So minimum is 2. Maximum, that is the number of members of a private company shall not exceed. So quorum for the gen shall be 2 members personally present. Okay, so 2. Okay, Parthrana, don't worry. Without prejudice, I will explain. 100% I'll explain without prejudice when we come to interpretation of statutes. There, the subject itself will be there. So at that time, I will explain, notwithstanding, without prejudice, subject to all that we learn when you come to interpretation of statute. Okay? At that time, I'll teach you. Transact business means to pass the resolution. Transact means to do. Transact is a big word for do. So do the business. So do means what? Basically, what is being done now? The chairman will read out the resolution. Then he'll ask, how many of you are in favor? They will raise the hand or poll or whatever. Then how many of you are against? Then if the number of votes is in majority, item passed. This is called one business over. This is called transacting the business. Okay. So this is what it is. And 200, absolutely correct. Divya Kumari 3. Madam, 3 is the minimum number of members of a public company. Hey, that is 7. What is this 3? Not 50, sir, 200. Okay, 200 members. 7 is the minimum number of members for a public company. Minimum, I'm asking for maximum. Maximum. Okay, maximum 200. Correctly said. See, this could come in an MCQ. That's why they could give you, they could ask. So, the above quorum shall be applicable only if articles do not prescribe a larger number. Please note, the company's articles can say other than 5, 15 or 30, but it cannot be less than 5, 15 or 30. But suppose a company says, for a public company, it says the quorum shall be 10 for the 1,000, or if it says whatever may be the number, our quorum shall be 50 members, then 50 will be the quorum. Also, but no company will do that, believe me. No company have ever done that. But they can prescribe a larger number, but they cannot prescribe a smaller number. Okay. So the word personally denotes that a proxy, that is a person attending the meeting on behalf of a member, cannot be counted in the quorum. Joint holders of shares shall be counted as a single member. Please note it. This is very important. You will have a doubt at a certain stage. So this is very important. Joint holders for the purpose of quorum. See, whenever we deal with number of members now, everywhere there will be different approaches. In some cases, joint holders will be taken as individual. But for the purpose of quorum, if joint holders are attending, they shall be taken as a single member. So if they can attend. See, if there are two members for the same share, there are two guys, owners, two joint holders. Then both can attend. But for quorum, they'll be counted as only one. Please remember, because the exam no problem, they could make this into an issue. They could say 10 members are joint shareholders, meaning 5. The 10 joint shareholders should be counted only as 5, because the pair of 2 will be taken as 1. Exceptions. Okay. Section 103 shall apply to private company unless otherwise specified in respective sections or the articles. So articles of a private company can provide for anything. They can even say quorum can be nothing or no need for quorum, and that won't do. They can prescribe larger. Okay. They can have other rules to a specified IFSC company unless otherwise specified. So many of these sections now, 101, 102, 103, will not apply to a private company or will apply to a private company subject to its articles. Meaning whatever is said in the articles will be applicable and not the act. Okay. So that is what we said now. Articles are superior to the act is superior to the articles and memorandum. But where the act itself says the articles can provide otherwise, then whatever is provided in the articles will be applicable. If the quorum is not present within half an hour from the time appointed for holding a meeting of the company. Now we are going to get into an important item. We said what is the quorum. Now we have to see what happens if the quorum is not present within half an hour from the time appointed for holding a meeting. Okay. So half an hour is given as a sort of a grace period for people to assemble, So the chairman cannot start immediately. Suppose the meeting is scheduled as 10, he should wait for half an hour. Then he can start. Then if the quorum is not present, meeting what will happen, we'll see. So if the quorum is not present within half an hour from the time appointed for holding a meeting, so within half an hour, quorum is not present, then a meeting, if called by the requisitionist under section 100, shall stand cancelled. Now, imagine, suppose I had taught you this section 103 first and not taught EGM by requisition, you will not understand what this is. That is why I taught that first. Okay? You know what that is, 100 now. Where there are members who want to hold an EGM, they will make a requisition under section 100. Within 21 days, the meeting should be called to be held within 45 days. If the board does not call or hold, the members themselves should call. Now, you remember that within 3 months, the members themselves can call and hold. So at that requisitions meeting, where the meeting called by requisitionist, got it? Not by the company, by the requisitionist under section 100. What happens? Quorum is not present within half an hour. Baba, you wanted the meeting here, you are not even able to get quorum, then the meeting shall stand. Sir, you understand? You only wanted, means the requisitionist only wanted. You guys were jumping up and down, meeting. So you called it. No, even quorum is not present. Get out. The meeting shall stand cancelled. See why I say even quorum, because quorum is the minimum number. Even that number you are not able to get. Then what are you? What type of requisitionist? Get out. Shall stand cancelled. The word used is stand. Stand means statutory. Whenever anything is statutorily done, the word used will be stand. Where it is not statutory, then it will be be. Shall be cancelled like that. And here stand cancelled. That means what? Statutory, no dispute. That's all. Half an hour over. Chal. Matter over. Go. Suppose three fellows are, let us say that the company is having 2,000 shareholders. 2,000 shareholders. How many people should be present? 15 members personally present. Public company, let us say. 15 members personally present. Only 10 are standing there in the hall. Half an hour over. Company is having 2,000 shares. Only 10 fellows are there. Quorum is not present. Therefore, they will say simply, please, carry on. No. In spite of that, if these 10 fellows try to do something, that will be invalid because lack of quorum will invalidate. Got it? Chalo. In other cases where the company is calling the meeting, the board of directors is calling the meeting, then the meeting shall stand adjourned to the same day in the next week at the same time and place. So, next week, same day, same time, same place. Or to such other date and such other time and place as the board may determine. So, if the board does not determine, then automatic adjournment to the same time, same day, same place in the next week. Got it? But if the board wants to fix, they will say, we will tell you when. In which case, they have to give fresh notice. Suppose they say, hey, quorum is not present, we will tell you when the next meeting, when the adjourned meeting will be held, then it is. Okay. So the meeting shall stand adjourned to the same day in the next week at the same time and place, or to such other time and place as the board may determine. Now, I want Mr. Srinivasan to answer my question, because he was asking the question now. What was the question he asked? Whether an AGM adjourned for want of quorum can be held on a public holiday. Can an adjourned AGM be held on a national holiday? Can it be held? What do you think? Because sometimes, I like students to, think. You got your answer now? Whose responsibility to check quorum? Chairman? Okay. What happens now? Suppose there is a chairman elected, then he should ensure that the quorum was present at the time of meeting. If the quorum is not present and he continues with the meeting, the proceedings of the meeting will be invalid. Once the chairman or chairperson is elected, he or she takes control. Everything responsibility becomes the chairperson. Okay. Why do you say it can't be held? Where does it say so? when the meeting is adjourned for want of quorum, what does it say? It shall stand adjourned to the same day in the next week or to such other date. Here it does not say to such other time and place other than a public holiday. So to answer got the point? See, this sentence does not say the adjourned meeting cannot be held on a national holiday. Even the board may determine, doesn't say, and if that day is a national holiday to the next work day, which is not a national holiday, it doesn't say that. Got it? But you can argue like this also because now see there's a conflict between 103 and 96. See, what does AGM provision say? AGM shall be held only on a public holiday, on a business, what is that, during the business hours and all that, right? See, what does it say? AGM shall be held during business hours on any day that is not a national holiday. My view is that it can be held. Provided it is adjourned for want of quorum. Be careful, my dear friends. Not any adjourned meeting. Hello. Only want of quorum. Please understand. Normal adjourn cannot. Okay, let us see what is Srinivasan's basic question. Can an adjourned AGM? No, sir. Adjourned. Suppose the board is, suppose the meeting is being adjourned normally. No. Sorry, I take back what I said. All of you are correct. There is Srinivasan's question. Answer is AGM, even if it is adjourned, cannot be held on a public holiday. But if an AGM is adjourned for want of quorum, please understand, if an AGM is adjourned for want of quorum, such an adjourned AGM can be held on a national holiday. Don't say public holiday, please. With folded arms, I'm begging you, do not use the word public holiday. Try to cultivate the habit of using the word national holiday. Why? Begging you, don't ask. It says national holiday, use national holiday. Okay? If an AGM is called by, beautiful question, Ritoji. I was going to tell you what you asked me. If an AGM is called by tribunal, then none of this will apply, ma. Whatever the tribunal says is final. If you go back to that note and read it now, you will find the tribunal can, in the order of the tribunal, can provide for many matters, na, consequential and incidental and consequential matter. One of the matters can be held on a national holiday, like that. Okay. So, your answer that an adjourned AGM cannot be held on a public holiday is correct. But please try to wrap your mind around what I'm saying. Where an AGM is adjourned for want of quorum, it can be held on a national holiday. Got it? Now, so this meeting is adjourned for want of quorum. If at the adjourned meeting also quorum is not present within half an hour, then the members present shall be the quorum. Members present shall be. So think about it. The board is calling for a meeting. EGM, whatever. The board is calling for a meeting. Meeting is started. Chairman. There's no chairman. Basically, it's the MD and all. See, in fact, to answer the question even better, whose responsibility Patsadi is asking now? Whose responsibility? Basically, who is interested in whose responsibility? That's all. Means the MD, so that who is interested in ensuring that the meeting should be validly conducted? The management. So they will be there definitely if they are calling. Whereas if the requisition is meeting now, they won't go. Why should they go? Because that will amount to giving respect to the requisitionist. No. See, you guys wanted, you means whenever I say you, not you. It's like a drama. I'm addressing those fellows. You guys wanted to have meeting. Go, have meeting, go. I am not going to call. So the law gives you the power to call within 3 months. Go, call. Let's see what happens at that meeting. So I will be sitting in the cabin. Maybe I will send my driver to just watch. Okay, go and see what happens, man. And then that fellow will be watching and calling me up. Saab, no, nobody has come, sir. Oh, really? Okay, what happened? Sir, only 10 people are there. Oh, okay, what to do? So that's all I'll be watching. Because that the requisition is headache. Suppose for half an hour the quorum is not present, they should disperse. That's all, matter over. But if I am calling the meeting, then I'll be concerned. So I'll come early, I'll be sitting, waiting. I will tell the company secretary, Mr. Company Secretary, try to get at least quorum members, man. What are you doing? Why am I paying you all like that? I'll be shouting at that fellow, and that fellow will be running around like a headless chicken, trying to get people, and they'll all come and sit and ensure that the quorum is present. But suppose the quorum is not present, then adjourn to the sentence. Now, that meeting, whoever attends shall be the quorum, even though I do not have the requisite quorum members present. Here, that adjourned meeting, at the meeting adjourned for want of quorum, can a single member constitute a quorum? Can a single member constitute a quorum? Okay, the answer is interpretation of General Clauses Act, or rather, application of General Clauses Act. An interpretation based on application of General Clauses Act. See, under the General Clauses Act, which you will be seeing, singular includes plural and plural includes singular. So, members include member, member includes members. So, though the section says members present, since the plural includes singular, a single member can constitute a valid quorum. This is an interpretation based on application of General Clauses Act. So, if you ask me, sir, members is plural, na sir, how it can be single members, sir? Because the General Clauses Act is saying plural includes singular. Similarly, this General Clauses Act is having another beautiful section which says male includes female, female includes male. Or words indicating the male gender include the female gender. So even though the he is used, it shall be made applicable to she, provided there is nothing objectionable to the usage. So long as that mixing of gender should not be objectionable. Correct. Exactly. Sometimes AGM is like marriage only. And the girl's father is the MD or that man in charge of the company. I have attended so many AGMs. If I tell you some of my AGM stories, there will not be time. Some of you will get angry. So I'm not going to tell. I've attended, as auditor, I've attended so many AGM. Literally, the MD will be pissing in his pants. I'm not telling something vulgar, but literally he'll be pissing. And I have attended meeting where the shareholders were so unruly. There was unruly behavior in the hall. And one of the shareholders pulled the tie of the MD who was sitting on the stage. Now, one of the shareholders, unruly behavior, he climbed to the dais and he pulled the tie of the, see, the MD was having tie of the MD. It so happens, I was also sitting on the dais wearing a tie. First thing I did, I removed my tie and put it in my pocket and I started, getting away from the place. No, I can tell you 100 stories like that. So the point I'm trying to make is, yes, AGMs are sometimes very, very, today, nobody bothers. Yeah. Today, it's all, this thing. Yeah. Law doesn't destroy grammar. For that, you need poetry because in poetry, you have poetic license. See, Shakespeare, in Julius Caesar, he uses when Antony speaks about the way Julius Caesar was murdered by the conspirators, he talks about Brutus. And he says, Brutus, that was the most unkindest cut of all. That was the most unkindest cut of all. See, already most is there, the superlative degree. So the correct English is most unkind. But Shakespeare is allowed to use a bad grammar. So like that, lawmakers are also allowed. This is not bad grammar. This is, see, the General Clauses Act is meant to make things easy. Meant to make things easy. So they say, in case by the parliament says he, don't ask only men. No, it includes for females also. Provided there should be nothing objectionable or abhorrent in the usage. Similarly, plural includes singular. Whether a proxy will be counted in the quorum, the adjourned meeting. Normally, no. Normally, proxy will not be counted. But where a meeting is adjourned for want of quorum, where a meeting is adjourned for want of quorum, at that adjourned meeting, okay, a proxy, because here they don't say members personally present. They are saying members present. Very, very important. Suppose they wanted to exclude proxy, they should have told members personally present. Since they are saying purely members present, therefore it is members present by proxy or in person. Okay. Slightly technical, but if you understand, it's nice. In case of an adjourned meeting or of a change of day, time or place, you have to give not less than 3 days notice to the members. So, for example, if you are going to adjourn, okay, see, this is not only for want of quorum. Any adjournment or change of day, the company should give not less than 3 days notice to the members, either individually or in public, which is in circulation at the registry office. Okay. Important, quorum shall be present throughout the meeting. Not only at the time of commencement of the meeting, but also while transacting business. So earlier view in the old law was quorum it is enough if at the time of commencing the meeting, the chairman counts the quorum. It is enough. If that time the quorum is present, thereafter, even if it is not there, meeting is valid. That was the view held in the olden days. Thereafter, the Institute of Company Secretaries has prescribed secretarial standards, of which secretarial standard 2 is a mandatory standard, meaning it is not recommendatory. It is compulsory. All companies have to apply. And therein, the company secretaries have said, quorum shall be present throughout the meeting. So, you have to count. So, every item of agenda, you should count whether quorum is present. Whether quorum is present. Members who are voted by remote e-voting have the right to attend the general meeting, and accordingly, their presence shall be counted for the purpose of quorum. Please note, later on when you come to e-voting, I'll explain. When e-voting is there now, they will vote through electronic means now. So their vote would already be registered. Now, the company cannot say, hey, you already registered your vote, now why are you coming in person? No. Even though he has voted by remote e-voting, he still has the right to attend the meeting. And when he attends in person, he will be counted for quorum. Okay. See, you might say, this is what's so important about it, sir. No, sir. Suppose there is a big fight between two groups of management. In the company, there are two groups. They are having a fight. Then this becomes important. Okay, the e-voting might be there. Some members who have voted may come in person. Question may be whether quorum is there or not. So at that time, so that for that purpose, they will be counted for quorum. So somebody should not say they have already voted by remote e-voting. How can they be counted for quorum? Like, a member who is not entitled to vote on any particular item of business, being a related party if present, shall be counted for the purpose of quorum. Means, normally, a person who is a related party, like a person who is a related party cannot, if he is a shareholder, he cannot vote. Suppose there is for example, partner of the MD is a related party. He is a shareholder in the company. Okay. On a particular item where he is interested, he cannot vote. Normally, related party can also vote. Approval of accounts, he can vote. But suppose a contract is being entered into between the company and the firm in which the MD is a partner, along with this other gentleman. That gentleman cannot. One second. Sorry. So a member who is so I give an example again. The company is there, MD is a partner of a firm, another partner is there. Now the contract is going to be entered into between the company and that firm. Obviously, the firm is a related party. Now the partner is also a related party. Therefore, and it so happens that he is a shareholder here. Now at the general meeting, when he attends now, on that item of agenda, on the approval of the contract item, the partner cannot vote. Even the MD cannot vote as a shareholder because they are a related party. But for purpose of quorum, both of them can be included. Even though he is not entitled to vote, he can be counted for the purpose of quorum. But his vote cannot be taken. Got it? The stipulation regarding the presence of a quorum does not apply with respect to items of business transacted through postal ballot. This goes without saying, Baba. Postal ballot means what? You don't have to come. The idea is you sit at home and you vote. So where is the question of quorum? Still our MCA wants to put sentences like this. They enjoy. Our job to read it. See, postal ballot, Baba, is where I sit at home, I write out, put it in the send it out. Where is the question of quorum? See, this is different from e-voting. Please understand. Postal ballot means there will be no meeting. So, in my humble view, this question of quorum itself does not arise because in postal ballot, there is no meeting. They will send, I will teach you later what is postal ballot. You will understand. Common sense, postal ballot. So, everybody will get the balloting sheet along with a self-addressed envelope. I'll simply take it, click. Then I don't have to sign also. It's pre-printed form. Fold it, put it in the cover, seal it, put it in the post. Self-addressed stamped envelope. Simply have to put it. That's all. On the appointed 30 days time is there. After that, they will, what all votes have received, the scrutineer will come and open. Then you will see how many for, how many against, declare. That's all. There is no meeting. So there is no question of a quorum for postal ballot. Still, for removal of doubts, they have given this. Whereas e-voting is different, where first there will be e-voting, then e-voting cutoff date will be there, then thereafter no e-voting, then there will be a regular meeting where members will attend. At the meeting venue also there will be voting facility. They can vote. Finally, at the meeting, the result will be declared. So there is a meeting. Got it? So even if I voted for the e-voting, I can still attend the meeting and will be counted for the quorum. I hope you have understood. Now here is a problem that you can try to attempt. Let's see if you have understood. Just see. Comment whether the meeting is properly convened meeting. So the answer should be yes, no. So the first question is comment whether the meeting is a properly convened meeting. The answer is very tricky. See, 11 a.m. appointed time 10:30. 11 a.m. Chairman proceeds with the meeting at 11. At that time, 18 members are personally present. 5 items are special business. So meeting goes on and on. See, from 11 a.m., fellows are conducting meeting, 2:30 p.m. Some of them got frustrated, maybe some emergency, whatever. 4 of them ran away around 3 p.m. Then the chairman proceeded with 4 and 5. Please. என்னது இது
இந்த எம்எஃப் சார் நாளைக்கு 50,000
நேற்றுக்கு மார்னிங்கே பண்ணலாம்ல எனிவே
எஸ் சார்
So the correct answer is the quorum for this company is 15. So at the time of commencement, 18 members are there. So 1 to 3 correctly transacted because quorum was present. But these 4 fellows left, what happened? Quorum has come down to 12. I mean, to 18 minus 4, 14. Now 15 is the required quorum. Therefore, quorum is not present for 4 and 5. Therefore, 4 and 5 not valid. After 4, within half an hour, see, around 4, within half an hour it is present. Okay. Ankur Patel, I will answer your question. Just give me 1 minute. Don't get excited and frustrated. I will answer your question. Sir, the meeting is not invalid, Manohar Yadav. Meeting is not invalid. Okay. The question is whether the meeting is properly convened. The correct answer is the meeting was properly convened, but quorum was not present throughout the meeting. Therefore, those items which were transacted when the quorum was present are valid. Agenda 1 to 3 valid. Agenda 4 and 5 not valid. Okay. So the correct answer is when it fell below 15, whatever was transacted at that time not valid. So whatever decision was taken by the members is not valid. But whatever was done before the departure of the members is valid. Meeting is not adjourned, ma. Meeting is very much. There's no need for adjourning. Why? Because at the time, see, within half an hour, the quorum is present. So meeting will not get adjourned. Chairman continues. Items of agenda 1 to 3 validly passed. Thereafter, these 4 fellows are going now. There, the chairman should say, don't go. Please be present. At least one of you be available to make it 15 and to ensure that 4 and 5. Chairman didn't think, was not properly advised. So meeting is not adjourned, Sohail. Meeting is not adjourned. Need not be. It is not statutorily adjourned. Need not be. Of course, the chairman, what he can do on his own motion can say, hey, if these 4 guys go, we won't have a quorum. So I am adjourning the meeting. Like that he can say. He can say, I am adjourning the meeting tomorrow to tomorrow. So, or later, whatever. If he is adjourning it, then beyond 3 days, then he has to give 3 days notice. Okay. But that's not what he has done. He has proceeded with the matters, which is invalid. Now, Anmol Patwa is asking a question, which is interesting. Let me take it up. Gap between 2 AGM shall not exceed 15 months. Then, in case of adjourned AGM, this 15 months calculated from the adjourned meeting or original meeting. Good question. Now, for that, the Gyan is very simple. Just remember, it is not as if they are 2 separate meetings. Okay. So, the original meeting is the meeting. The adjourned meeting and the original meeting together become a single meeting. So, for counting AGM 15 months, you have to count only from the date of AGM, meaning the original meeting. Okay. The adjourned meeting sort of gets combined here. It's a continuation of this meeting, which was convened on the particular day. Now, that day will be this may be adjourned 3 times. Whatever may be the adjournment, for purpose of 15 months, you will take only the date of the original meeting. Very good question, Mr. Anmol. Very good question. So the answer is, first point is the original meeting and the adjourned meeting together, single meeting. For calculating 15 months, we have to commence only from the original meeting. If a director's member, then will he be counted for the purpose? Yes, if he is a member, he will be counted for quorum. But if there is a benefit to the director or a related party in which the director is related, then he will be counted. Please note, this is what it says here. A member who is not entitled to vote on any particular item of business. For example, an MD is not entitled, MD may be a member, but he will not be entitled to vote on any business where he is a related party. Even though he is not entitled to vote, he shall be counted for the purpose of quorum. Okay. Have you understood, Mr. Banerjee? So this is another question. An extraordinary general meeting of Bug Hunt Limited, an unlisted public company doesn't matter. Public company, that is important, was held on 15th March 2022 at 11 a.m. The company has 6,500 members. Around 11:30 a.m., about 12 members in person and about 100 proxies are assembled. The proxies claim that there is a valid quorum. So obviously, see, these are the proxies. They are ordinary fellows now. They won't know anything. So, is the quorum present? If I am writing an answer for this question now, I will write like this. At an extraordinary general meeting of Bug Hunt Limited, which has 6,500 members, within half an hour from the time appointed for the meeting, 12 members in person and 100 proxies are assembled. Full stop. Then I will write the provision relating to proxy, this one, where the company has, where the number of members of company as on the date of meeting exceeds 5,000, then the quorum shall be 30 members personally present. Then I will apply the law to the fact. So I will give the fact, then I will write the law single line. Where the number of members of a company on the date of meeting exceeds 5,000, the quorum shall be 30 members personally present. Then I will apply the law to the fact. What I will say, in the given case, the number of members present in person is 12, which is less than 30. Therefore, the quorum is not present. That's it. Then one line. What is the who is correct? Therefore, the chairman's view that quorum is not present is correct, or therefore the chairman is correct. Full stop. What are the legal consequences? Now, here you have to write the law here, where the quorum is not present within half an hour from the time appointed for the meeting, then the meeting shall stand adjourned to the same time, blah, 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 blah. Everything you have to write. So this question will carry 5 marks. Okay? You'll get marks. Okay? That's how you have to write. Don't write too much blah also. See, this is not where you get more marks by writing more. No. To the point. Okay? Somebody was asking me how to write. I hope that gentleman or lady is listening. I have given exactly how I will write this answer in the exam. And I will write it very neatly in a neat handwriting and present it well. So, this is what I know, sir. Beyond this, if you have any doubts on how to write and all, sure, there are people who are more intelligent. They will teach you. Not me. This is what I know about writing exam, clearing exam and all that. This is all I know. Okay. So, my level of knowledge has been reached. I'm sure there are better people who will tell you. And definitely, Board of Studies has got expert faculty. In case you have a doubt, little later, there will be a day when for half an hour, the Board of Studies expert faculty will tell you not just how to write answer, but general queries also they will answer. So I will tell you at that time, you can ask. Okay. I am a very, very ordinary fellow. I don't know many things. So whatever I know, I'm sharing with you. So chairman is correct. The quorum is not present. However, if the proxies are present at the adjourned meeting, then they shall be counted for quorum. Correct. Exactly. So if beautifully written, Rituraj. See, this is the consequence. See, at the adjourned meeting, if these 100 fellows come, then even though only 12 are there, meeting shall continue. Members present, including proxy, shall form a quorum. Beautifully said. If that EGM is called by, sir, what is your doubt? What is your doubt? A meeting, if called by requisite, shall stand cancelled. Okay? And this is not a case where meeting is called by requisition. This is a regular meeting. Okay. Now, adjournment. Basically, adjournment means the meeting, it is decided to have it at a later date. When the meeting is scheduled for a later date at the meeting, whether by choice or statutorily, for want of quorum. Postponement is when the meeting is scheduled for a later date before the date of meeting. So we call the meeting on 18th January. We know that some calamities come or we fear that COVID may be coming again, lockdown, whatever. So we are saying we are postponing the meeting, whatever. Cancellation is when a scheduled meeting is not held. Maybe that is a correct example. See, we have scheduled the AGM on, we have scheduled the EGM on 18th. Now, suddenly we find that something is there when we cannot hold it on that day. So we postpone the meeting, say 10 days later. Postponement before the date of meeting. Now the meeting is called and held and conducted. At the meeting, the chairman says, we need more information. Let us adjourn. Or quorum is not present within half an hour, statutorily adjourned. That is called adjournment. At the meeting, we decide to schedule for a later date. Cancellation. We call the meeting on, say, 18th of January, but suddenly there is a news that COVID is now come again. So we are going to be asked by Modi ji to stay at home again. 100% it won't happen till 22. Don't worry about that. After 22 only. Before 22, even if COVID is there, nothing is going to happen. Okay. So if that announcement is coming, then meeting cannot be held. So we will cancel the meeting. Act of God, pandemic, etc. The meeting was held through electronic mode, quorum of meeting. See, again, you should understand where the meeting is held through electronic mode, as of now, they are not having pure electronic mode. As of now, actually, that meeting through electronic, virtual meeting was an experiment during pandemic. And that was allowed only for certain companies, and it was under rigid control, it was done. So thereafter, they have stopped it. It is not possible. Nowadays, there is no virtual meeting. Even if you hold a virtual meeting, I showed you AGM of Reliance. Even that was a virtual meeting. Even then, there will be a physical meeting where members can come in person. There, their attendance will be counted. Only those who come there in person. You understand? Those who attend virtually won't be counted as of today. As of today. But going forward, as of today, to answer your question, virtual, don't say meeting through electronic mode. Voting through electronic mode. Meeting, it's called virtual meeting, where persons attend non-physically. Today, such a meeting is not possible. Means you can have telecasting, you can have people attending through link, etc., through webinar and all. But there should be a physical meeting. And those who attend that meeting, quorum should be present. So that is how happening now. But as early as 2000, I suggested that virtual meeting should be held. In 2000, I said virtual meeting can be held so that people can stay at home and attend. Today, it is a reality, but still the law is not matured enough to understand it. During pandemic, they permitted. How? They said you have a physical meeting with the pandemic number, 50, 100, but the other members can attend through. But those who come physically should form a valid quorum, meaning more than 5,000, 30 fellows should be personally present. Postponement was, again I'm telling, you are holding the meeting on, you are proposing to hold the meeting on 18th. On that day, you find something is there which you cannot hold due to some reasons. Then you will make an announcement to the members that the meeting scheduled on so-and-so date will be held on a later date, maybe on 25th of January, for which you have to send us, again you have to send a notice. Adjournment is when the meeting is called and started. Meeting is going on. During that meeting, when the meeting is going on, the chairman decides. We will not continue. The meeting stands adjourned, or the meeting will be adjourned. Either I will tell you the date, or he will give the date also. On such and such a date, we'll meet again, by which time we will come prepared with the data and explain to you like that. Cancellation is when a scheduled meeting is not there. Have you understood, sir? Please, if you have understood it, kindly now explain. Sir, right? Don't copy, Mr. V. Don't copy anything from the board. Don't copy anything from the slide, because all these slides will be given to you after the last date of this session. Please watch my lips. Others also. Whoever is saying, please send the notes, please send the notes. It will not be sent. This note will be sent only after the last session is over, which will be next Thursday. Inshallah, when the last session is getting over, it will be sent. Till then, it won't be sent. Thereafter, maximum 48 hours, I don't know, it will be sent. Till such time, your institute ka material hai na, read it. You love to read it, na, read it. When my notes come, you can read it. It is not as if day after tomorrow you're going to read it. Yeah. Read. Nearing the exam, you use my notes. Okay? See, some student will tell as if, if the notes are not there, my entire preparation is gone, my entire thing. Not like that. After all, my notes have been used by students, even though they have not attended, they have come to know about it and downloaded it from the Board of Studies portal. They read it. They have not attended my lectures also. Some of them have downloaded my video lectures and they have listened to it. And they say they have got 60 and all that. Even though, like Ekalavya, they never attended my class, or they virtually live, they never saw me. It was only a video they saw. And with many have written mail, when messages will come to me, somehow they'll go to LinkedIn and get become my friend. Somehow they'll get my email ID or whatever, my WhatsApp number, and they will come. And they will say, I went through your notes here. So, no problem. Everything is there. Don't worry, you get it. Act of God was. So Chennai flood was an act of God. You all were inquiring, how are you safe? Are you safe? Any natural calamity is an act of God. Sir, this word act of God should not be new to you. You would have studied it in college, when you studied Contract Act, impossibility through act of God. See, you enter into a contract, then supervening impossibility, where there is an act of God by which the performance of the contract becomes impossible. That is called act of God. Anything on which you and I have no control is an act of God, Baba. Like flood, tsunami, earthquake, pandemic itself is an act of God only. Means that which is not in our control, right from the primitive ages, we called it an act of God. So when we did not understand it, we looked up at the sky and we prayed. Okay, and we called it God. Okay, so that is what it is. Adjournment should be statutory. We already saw, in which case the meeting stands adjourned. Non-statutory or by volition means choice. The chairman decides. It's called adjourned. He's adjourned. Non-statutory. I'm further going to non-statutory, where the chairman decides, then the adjournment can be sine die. Sine means without. Die means date. So the chairman will adjourn the meeting without a date. So he will simply say the meeting is adjourned, like that. But the meeting may also specify the date of the adjourned meeting. So the chairman, while adjourning it, non-statutorily, can say sine die. In which case, you have to give notice. Whereas if you mention the date, then no need for notice. But if the date you are mentioning is more than 30 days, then you have to again give notice. This is the general rule. See, suppose I am the chairman and I am adjourning and saying, hey, today we are supposed to have a meeting. I think it's not going to happen. We are not having all the data. Let's adjourn the meeting. Let's have it on the 5th of February. Then I have to give notice. Or suppose I say, boss, I'll tell you what, we'll adjourn this meeting. I'll tell you when we'll meet again. That is called sine die. I have not given the date. Then, whatever date, I have to give a fresh notice for the adjourned meeting. Okay? Sine die is a Latin term. Sine means without, die means date. Die, not die, death. Die means date. Okay? Sine die. Actually, there is an English word called sincere. Sincere means a person who is honest, honorable, like that. Sincere. Okay. That word is taken from an old Latin word, which is sine cera. Sine cera. This means in those days, when they used to make marble statues, there may be a small flaw, dent in that statue. Okay. In order to cover up the dent, or in the pot, or the vase, there will be a small dent. In order to cover up the chip, what they will do, they will put a little bit of wax on it, cera, that's called wax, and they will sort of do it in such a way that it won't be visible. But it is a flawed product, whereas a good product which has no flaw is called sine cera. There is no such thing. So later on, that sine cera became sincere. So a sincere person is one who has no flaw, who is not hiding anything, who is open. Okay. Sorry, this has nothing to do with company law. But I'm trying to provoke an interest in you in learning English words and understanding the roots of those English words. See, when you read a word in English, remember, it has something called etymology. That word has a history. And you don't think that for knowing that history, you have to go to some library, sir. Kar lo duniya mutti mein, aapka mutti mein hai. You just go to Google and write the word with etymology. Google will tell you. That too, if you're having AI-driven Google, beautifully it will tell you what you want to know. And you can learn so much. Okay? Your teacher is not here. Your teacher is here in this. Carlo, in those days, Dhirubhai, when Reliance Com was formed, he gave this slogan. He said, Carlo Dunia Mutti mein. I loved that. Because today, my world is in my palm. Anyway, maybe the law wants company to conduct physical meetings so members catch MD's. That's good one. In fact, that meeting where the MD say was catched, what happened? What happened was that the MD was in a hurry to run away. Even I was in a hurry. The company secretary was there. I grabbed the company secretary's hand and we came down by the service elevator. The MD jumped by the window. Before jumping, he called me on the mobile at that time and he asked,
Srikanji, what to do? What to do? I said, sir, first you adjourn the meeting. So immediately he shouted in the mic, the meeting is adjourned, sign a die. Then he jumped from the window and ran away. Then later in the evening, 3 p.m., we met and we gave fresh notice and we called the meeting. At the time, only 4 people came, no time, nothing. Meeting went on, we passed the agenda. At that time, the quorum was only 5. In the old law, the quorum was only 5. That's what I'm telling you now. Just if I write my AGM examples now, I can tell you there are so many cases. But as you rightly point out, Rudraj, the intention of the law is that members should be present and discuss. Okay? So they want to have physical meeting also. In extraordinary cases, only postal ballot will be given. Okay? Why most of the Latin words are used? Simple, sir. The original source of law was in Rome. See, the first ever written law was in Rome. The first ever written law was passed by the Senate of Rome, where the law was written on leather parchment, leather, thin sheets of leather. The written law was first in Rome, and that was written in Latin. Thereafter, when Rome conquered Britain, they brought this Roman law to Britain. Then Britain conquered the whole world now. So Britain, for a long time, retained Latin as the language of government and proceeding, not just legal matters, but also government proceedings. So when the king, when the king gave an order, it was written in Latin by the priest. And the Roman Catholic Church, even today, uses Latin. In all the liturgy, they use Latin. Okay? So Latin was the official language for a long time. Thereafter, when Britain conquered the whole world, early stages of colonialism, Latin was the legal language, which is why your Mohandas Karamchand Gandhi, when he went to London, he learned Latin because he wanted to become a lawyer. So Latin continued to be the word. Later on, with more and more clarity, English became the sort of language. French became whatever. Local languages came. Even then, some technical terms continue to be retained in the old Latin format. So many of these words you use are Latin. Okay, that is why Latin is used as a thing. Chalo. Where a resolution is passed at an adjournment meeting by a company or the holders of any, the resolution shall be treated as passed on the day it was actually passed and not on any earlier day. Please remember, for counting the date of the meeting, we will take it to the original meeting. But for passing, the date of passing, we cannot go back to the original date. It should be taken only on the date it was actually passed. Please understand. I said, for somebody was asking now, whether for counting 15 months, should I count from original meeting or from adjourned meeting? I said you have to count from the original meeting. But suppose a resolution is passed at the adjourned meeting, I cannot use this rule and say, hey, it is deemed to have been passed on the earlier date. No, the resolution shall be treated as passed on the day it was actually passed and not on any earlier date. They make this point because as far as the meeting is concerned, the original and adjourned together form a single meeting. Okay, now we move on to proxies. What I thought, it is exactly 7:30. Even I'm feeling a little, I want to drink a little hot water. So I will sort of do that. Okay, so we'll have a break for 5 minutes. Sir, 5 minutes ka break.
Okay. Welcome back from your well-deserved break. In fact, somebody, Aparna ji, wanted 10 minutes. I've given you 10 minutes break. And so we move on to the next topic, 105 section, which is who is a proxy or proxies. Now, your question would be, who is a proxy now? What is a proxy? So first you have to understand who is a proxy. Proxy is the term for a person who attends any general meeting of a company on behalf of a member. See, you are supposed to attend the meeting of a company. You have you are not able to go for some reason, but you still want your vote to be cast. So you will call your friend, somebody, and say, hey, you go. So that person who attends on your behalf, like your agent, is called a proxy. The word proxy has been used by some people in college also. Remember, where somebody is going, not in the class, professor is calling attendance. So he'll say, so-and-so, immediately somebody otherwise will come, present sir, like that. Some intelligent professor will know who is calling. So they'll ask, hey, where is that fellow? Like that. He's not there, mark absent. That's called giving proxy, where you answer for somebody who is not present. That it used to happen, proxy. But proxy is a person who attends on behalf of them. Also, the authority by which he attends now. So when the proxy comes to the meeting, he cannot say, I am the proxy for A. So there should be some proof. Instrument should be there. Instrument means document. So if you don't like the word instrument, chhod dijiye. You use the word document. So proxy is the document by which the authority is given to the proxy. The proxy is authorized by the member to attend the general meeting on behalf of the member. So again, as I mentioned to you, once more I am clarifying, member who attends by himself is attending in person or through personally. Whereas when a proxy attends on behalf of a member, the member is said to attend through proxy. Please don't say proxy is attending. Proxy is attending on behalf of the member. So it is a member who is attending through proxy. Okay. This is a little technical, but try to process it. Any member of a company entitled to attend and vote at a meeting shall be entitled to appoint another person as a proxy to attend and vote at the meeting. So this is a fundamental right of the member. It cannot be denied. The articles cannot deny this right. Member who attends himself is said to attend. We already seen this. Unless the articles of a company otherwise provide, the above provision shall not apply in the case of a company not having share capital. Why? The reason will be apparent to you once you see the rights of a proxy. See, when the company does not have share capital, how is the voting done? Think. I told you. When the company has share capital, voting can be by show of hands, in which case one man, one vote, or on a poll. On a poll, one share, one vote. On a poll, P-O-L-L, one share, one vote. Whereas company not having share capital, there will be no poll. Only voting by show of hands. One person, one vote. Therefore, even if the proxy comes, he cannot do anything because proxy cannot vote on show of hands. Proxy can only vote on poll. Whereas for a company not having share capital, there can be no poll. Only no proxy. So proxy has no meaning. Therefore, there is no need for a proxy. Okay, you got it? Later on, you'll be seeing that proxy can attend on behalf of a member. For what purpose? For eating jangri? No. For voting. How? On poll. He cannot vote on show of hands. Got it? Therefore, for a company limit not having share capital, there is no need for a proxy. Either you come or don't come. If you come, raise your hand. If you don't come, that's it. Your vote is gone. Got it? That is why, see, this company not having share capital will be very rare. And most of the time, this company not having share capital will be Section 8 company, which will be known people. Got it? So they will all come in person and they will vote. If they don't come, they don't come. That's all. Got it? The central government may prescribe a class or classes of companies whose members shall not be entitled to appoint another person as proxy. Such cases have not been prescribed as of now. But the power is there with the central government. The form, the instrument means any document by which a right is conferred in them. Later on, when you come to interpretation of statute or the general clauses, we will see what is an instrument. Instrument is any document by which a right is created or obligation is accepted. Whatever. So rights and obligation. So basically, a lease agreement is an instrument. Got it? A promissory note is an instrument because rights are created through the promissory note, right? Like that, there are many cases. Any piece of paper through which a right is created or an obligation is accepted or both is an instrument. It's easy to understand. Okay. Suppose you take a piece of paper and write, I owe you 500 rupees. Instrument. Okay, because I have a right to receive 500, you have an obligation to pay 500. And it should be on a paper, on a document. It's called instrument. So here, that instrument appointing a proxy, so the form of appointing a proxy, because right is there now. There is a right of the proxy to attend the meeting being created through this document, and also his obligation to attend and vote. It's created. So the form of appointment of proxy shall be in the form MGT 11. What is the MGT? Management and Administration short form. MGT. Okay. Who decides how these abbreviations are done? MCA, some gentleman at that time, Big Shot must have decided. Who don't know who it is. So don't ask me why MGT, why not MAD, Management and Administration, or MAA, Management and Administration. I don't know. Or MAD will be the right one. Management and Administration. Okay. Chalo. The instrument appointing a proxy shall be, because this MGT 14 is a very, very important form. Later on, we'll see it. Whenever a special resolution is passed or certain resolutions are passed, you have to file MGT 14 within 30 days. That MGT 14, these company secretaries will, whatever else they do, they'll file that MGT 14 correctly. Within 30 days, MGT 14 should be filed. In those days, it used to be called Form 24. Now it is called MGT 14. The instrument appointing a proxy shall be in writing. And it should be in writing. Oral, not possible. You can't call up the MD and say, you know what, I'm sending John as my proxy tomorrow. Please allow him to vote. No. The proxy shall be in writing, should be signed by the appointer, meaning the member, or his attorney, meaning a member may not be in India. He may be in foreign country. He may have a power of attorney, agent, who is duly authorized. Such agent can appoint proxy. Okay. If the appointer is a body corporate, it should be under the seal, if it has a seal, or signed by an officer or proxy authorized by it. Okay? I mean, a power of attorney authorized by it. The idea is that instrument should be in writing and signed by the appointer or his agent. Okay? If you want, very easily I will explain this. The instrument should be in writing and should be signed by the appointer or his agent. It's all right. The proxy shall be filed with the company at its registered office not later than 48 hours before the meeting. Meaning, if the meeting is going to start at 5 p.m., then the proxy should be deposited 48 hours before the meeting, not later than 48 hours. So the articles cannot prescribe a period beyond 48. Meaning, you cannot say, if you want to appoint a proxy, you should appoint, the instrument should be delivered 72 hours before the meeting. If you say anything above 48, then it shall be read as if it is a period of 48 hours. If the articles are providing a period more than 48 hours for depositing the proxy form, it shall have effect as if 48 hours has been specified. So, idea is, you cannot say you deposit it 1 month before. No. As I can come 48 hours before and deposit it also, she can attend. But at the meeting, the proxy cannot walk in, throw the proxy form and say, hey, I'm a proxy. Sorry. Because if the articles say 48 hours. Now, some companies may have 24 hours, 7 hours. Lesser now can be given, but greater cannot be given. The Articles of Ultima Software Limited provides that proxy should be deposited 72 hours prior to the meeting. Sushil has been appointed as proxy of Shekhar Verma to attend the AGM to be held on 22nd July 2022 at 10 a.m. He deposited the proxy form with the company at 9:30 a.m. on 20th July 2022. right? See, the years don't really matter. The principle is more important. Suppose they change this to 23 also, nothing is. In the exam, they'll definitely give you latest years. See, many questions are repeated in the exam. What they will do is only change the date and the year. That's day, not even the date, the year they will change. That's all. Because the principle is the same. Okay. So what is the principle here? The articles provide 72 hours. Sushil is appointed as proxy for Shekhar. Now, Sushil deposits the proxy 9:30 a.m. on 20th July, which is more than 48 hours, but less than 72. The MD of the company is saying it is invalid. Is this view correct? No, the MD is wrong, because even though the articles provide 72 hours, it shall have effect as if 48 hours has been prescribed, which means Sushil has correctly deposited the proxy within not earlier than 48 hours. Okay. If a member is a body, if a member is a body corporate, actually the body corporate, can the person attending on, this is what it says now. If the member is the appointed is a body corporate, then that person appointed, there will be a proxy. Earlier, company could not appoint a proxy, body corporate and all. They will appoint a representative. Now they said, if you're a body corporate, no problem. You appoint a guy, we'll call him proxy. Just see to it that it is signed by the officer or attorney, or you are giving it under the seal. See, if the body corporate seal is to be affixed, it can be affixed only at a board meeting. And the affixation should be witnessed by 2 directors. Please note, simply you cannot affix the seal and send. There should be a board meeting. In that minute should be there. So-and-so was authorized to attend the meeting of this. The necessary instrument in MGT 11 was duly, the seal was duly affixed, and so-and-so and so-and-so have signed it in witness thereof. So they both should sign. So all this hullabulla is there now. Better you ask an officer to sign it. Yeah, that's better than seal. You ask the MD to sign it and send it. That's easier. So that person who is attending now will be called a proxy only. Will be called a proxy. So instrument appointing a proxy, if in the form MGT 11, shall not be questioned on the ground that it fails to comply with specific relation to such instrument by the articles of company. So long as it is in the form of MGT 11, it is enough. The company cannot prescribe other conditions. It should be on green paper and all that. No. Now, very, very important. Very important. Proxy shall not have the right to speak at the meeting and shall not be entitled to vote except on a poll. So, first of all, proxy cannot speak. Why? Think about it. I'll give an example. My parivar is meeting, sir. Myself, my sons, their wives, the grandchildren, we are all meeting. My brothers, their children. So, big parivar ka meeting hai. Now, at that time, what happens now? One of my son's wife's elder brother is coming in. He's saying, uncle, I'm coming, but I'm representing so-and-so in this meeting. So I said, chal, no problem, you come. Just for the sake of expressing his view, means voting, you come. But then during the discussion, suddenly this brother-in-law stands up and says, no, uncle, if you remember in those days, I say, hey, chup, who are you? You are not a member of my family. You are only a proxy. Why are you here to vote? You vote and go. You have no business to speak at this meeting. Are you able to understand the logic? The proxy is a third party. He cannot, see, a member can ask. A member can stand up and ask the MD, Mr. MD, I want to know why you went to Singapore in September. I have to answer. Because I booked a foreign travel expenses, I have to answer it. But you are a proxy. You are a third party. You come only for voting. Baba, your job is only to vote. When the poll is there, you vote. Till such time, chup. So, proxy cannot have the right to speak at the meeting. The logic is he's not this. He's a third party, stranger. Cannot. One more thing, he can only vote on poll. He cannot vote on show of hands. Why is this so? See, think about it. Can a person be a proxy for more than one person? Yes, he can be. Now, let us say that a person is proxy for 5 people. Okay, later on, we'll see there's a ceiling on that, but assuming he is a proxy for 3 people now. Now, on show of hands, he is representing 3 people, boss. How many hands will he raise? Yeah. Wait, I raise 1 hand. Then one more hand. Then I will lie down on the ground and raise my leg. Even assuming I have only 2 legs. Am I Ravan that I have 10 hands? Think about it. Okay. So whatever it is, I cannot raise. So physical impossibility. They say no. But proxy can demand a poll and vote on a poll. This is what I said. I gave the example of I will show you the corporate dynamics when a single proxy can change a meeting. Think about it. 10 members are attending. 10 members are attending. 10 members are attending. Together, those 10 members hold 40% of the paid up share capital. 10 members, 40% paid up share capital. 10 members, 40% paid up share capital. One proxy holding 60% PSC, paid up share capital. Now on a poll, the total voting power is 100%. Now, proxy is having 60% of the total voting power. Right? Now, meeting is called. 10 members come. Less than 1,000. 5 members is enough. Quorum is present. Chairman proceeds with the first item of agenda. Proxy keeps quiet. 10 members vote. Proxy doesn't even question because that is not important. Third item of agenda, removal of director, means removal of the person who is represented by the proxy, who is possibly sitting in Singapore. That item is taken up. Okay. Now the 10 members are looking at the proxy because the fellow should not be here, but he's here. And but what will proxy is keeping quiet? Nothing. He's not talking anything. Then they say, we will now take up item number 3, removal of so and so as the director of the company. All those in favor, raise your hand. 10 members will raise the hand. At that point in time, the proxy will only make one statement and the entire meeting will change. You know what he'll say? You politely stand up. You won't have to shout and all. He'll stand up and say, Mr. Chairman, I demand a poll. That's all. Everything gone. Because on a poll, what happens? One share, one vote. I control 60%. You have only 40. All 10 of you together 40. Whereas this one proxy 60. So on a poll, the proxy will win. That man cannot be removed. Are you able to understand the dynamics of corporate management? So see, the only bad luck for these 10 fellows was the proxy attended. See, you should understand it from a very exciting way. These fellows might have done something to prevent the proxy from attending also. So maybe they like Tom Cruise, you would have taken a Ferrari or a Maserati and you would have driven and you would have come through the traffic and all that and jumped and directly entered the member, GM, general meeting. They would have been shocked how this fellow came. And proxy would have been deposited 48 hours, don't worry. So he will have the copy of the proxy form, come and stand. And when the meeting goes on, then he'll say, Mr. Chairman, I demand a poll. That's all. He can do many, many things, including he can elect himself as chairperson. On a poll, he can say, let's have a poll, Baba. Because on a poll, every time on a poll, I will vote 60, you will vote 40. Yeah, all of you vote, still you are only 40. I vote, I'm 60. This is the beauty of corporate democracy. I call it corporate democracy. This is not the same as normal democracy, where more money, more power. More control, more power. More risk, more power. See, think about it. The guy who's got 60% stake, he's got more risk in the business here. Whereas the guy who's got 40%, these fellows, they got lesser risk. So the law feels the higher the risk, the more the control. Okay. Just I'm explaining this to you, help you understand the principle behind this concept. Now, so this is just to help you understand. I hope you have understood this concept. So, anyway. Now, should a proxy be a member? No, a proxy need not be a member. A member of a company registered under Section 8 shall not be entitled to appoint any other person as his proxy unless such other person is also a member. See, suppose there is a share capital, then you can appoint proxy. But for Section 8 company, the proxy should also be a member. Normally, proxy need not be a member. Exception, Section 8, where the proxy should be a member. Can a person act as proxy for more than one member? Yes. not exceeding 50 members. A person can act as proxy on behalf of not exceeding 50 members. 50 members, you can be a proxy, which is pretty good. See, when there's a big fight between two people in a company now, they will go for proxy hunting. So at that time, they cannot have so many proxies. Now, so 50 members together can appoint one proxy. Like that, they will consolidate the proxies and the huge proxy battle. So just like the 60% wala is one proxy, na, they will try to push as many proxies as possible. The ordinary shareholder cannot come now. So they will go house by house. They'll go to each house. They'll visit, sir, please sign the form, sir. Please sign the form. Then all of that will be deposited 48 hours before. And then all these proxies will come. Each one controlling 50 members ka shares. So it will be a real nightmare. But idea is to win. Who will win? Who will win the vote polling? So like that. Okay. So a person can act as proxy on behalf of not exceeding 50 members, but those members holding in the aggregate not more than 10% of the total share capital of the company carrying voting rights. So all the 50 members together should not hold more than 10% of the total share capital carrying voting rights. So there's a two cap. 50 plus that 50 should not hold more than 10% of the total share capital. Member holding more than 10% of the total share capital of the company carrying voting rights may appoint a single person as proxy. Okay. Such person shall not act as proxy for any other person or shareholder. So if one single member is holding more than 10%, then he may appoint a single person as proxy, and that person cannot be a proxy for anybody else, any other person. Got it? So here is the situation. Ultima Software again. Sushil Menon is going to be appointed. Remember, Shekhar Verma appointed him. Like that, a group of going to appoint. Okay. So Sushil Menon is going to be the proxy for these people. Achyut Menon, Anant Vasudevan, Keshav Kurup, Narayan Munni Nayar, Shekhar Verma. So see the percentages. These are the percentages held by them. Right. Now what happened was, see, originally Shekhar Verma appointed him. Right. Now Shekhar Verma is holding 12%. Now he possibly said, hey, let's appoint Sushilia. Come on. So they were all having a drink in the bar. They said, hey, for that meeting, now, Bagar, we should do something. Yeah, let's send Sushil Ma. He's the best guy. So all these guys said, okay, we will also appoint. So all of them did it. And then now what's happening? Sushil is now going to be a proxy for these people. Is the proposal valid? It is invalid because two things. One, see, together, let's count 3 plus 2, 5 plus 5, 10 plus 12, 22. 22%. Whereas proxy can be not exceeding 50 provided they hold in the aggregate not more than 10%. So this is more than 10%. One. Two, one member holding more than 10% can appoint only one proxy, and that proxy cannot be proxy for others. So what they should do is find one more guy who will represent 1 to 4. Shekhar alone should have Sushil. Then only it will be valid. Otherwise, it will be invalid. Nancy wants to know what is the meaning of Mr. Chairman, I demand a poll. See, later on you will come to poll. Poll means where the voting will be done based on the number of shares. So you have not quoted me correctly. Nancy, even while quoting me, you have not quoted me correctly. I didn't say need a poll. I said I demand a poll. There's a difference between demand and need. Okay, when it is a right, I can demand. I don't have to beg. So demand a poll. What does that mean? The proxy is telling, sir, voting by show of hands is not enough. The voting should be by polling. Let us have polling sheet and we will vote. If so, then on a poll, one share, one vote. Can you understand this, Madam Nenshiji? On a poll means when a poll is taken, one share. Hey, you have voted in the election. That is called polling now. But there, remember, you go and vote only one vote. But in company, one shareholder votes on a poll. It is not one vote. One shareholder votes one vote into how many ever shares. So if I'm having 100 shares, my one vote is equal to 100 votes on a poll. That is why proxy will see he is having 60%. Suppose the company's share capital is 10 lakhs. This man is holding 6 lakhs. shares. That man is old. All of them 10 together are holding 4 lakhs. So every time this guy votes, now 6 lakh votes, whereas that guy will have only 4 lakh. What? One member holding 50% come no. See, what does it say here? Member holding more than 10% may appoint a single person as proxy. So one thing I'll tell you, suppose you are holding 50, you can appoint 4. No problem. No problem. But those 4 people cannot be proxy for anybody else. You can have more than one proxy, but those guys whom you are appointing now cannot be proxy for any other person or shareholder. Got it? But why would you want to do it? Huh? Waste of time. Huh? You are holding one man. See, in my example, 60% one proxy is controlling. Why have more than one? What fun, what joy in doing that? Simply for questioning, you should not ask. There should be some practical relevance. Why will you, if you're having 50%, one man, why are you having 5 people, 4 people? Seriously, I'm not able to understand the logic. Sorry, Harendra Sharma, why would you do that? Don't do that. One proxy is enough. Why more than one? If they exclude Sushil Verma, then they can appoint. Correct. If they exclude Sushil Verma, no. If they exclude Shekhar Verma, then they can appoint Sushil. Okay. That's how it should be done. See, at that time in that bar, when they are all drinking, you should have been there. And you should advise them, no, don't do that way. I'm doing CA, section 105 of the Companies Act, says like this. Oh, is it so? Oh, wow. Okay. What should I do? Then you tell them, you 5 guys appoint me. Shekhar, you appoint Sushil. No, we both will go. Okay. See, this is the advantage of reading company law. You can impress people with your knowledge. In fact, many times, once you complete your intermediate, when you attend marriages and all, once they come to know that you are a CA and the 2 intermediate completed, finalist, 100% one uncle or auntie will come. Uncle usually will come and they will ask you, I have a house in Mulund. I am planning to sell it or whatever in Ghatkopar. I am planning to sell it. I'm going to buy another house in Mulund. Do you think I have capital gains? They will ask. The entire capital gain consultation that fellow will try to do in wedding reception. Can you imagine? It's happened to me, not in Mumbai, but in Chennai. Okay, Mr. Srikanth, you are a chartered accountant. Yes, unfortunately, I'm a chartered accountant. Tell me. So they will ask, you see, I'm doing like this. What do you suggest like that? No, they will ask. So what to do? You have to give, because like a doctor, they will take free consultation. Like that auditor also, they'll take free consultation. Whatever you want to do. You can't also refuse. But at some stage, if they ask too much complicated, what I have been taught by my guru, Professor R. Bhupati, when they ask like that, do not say, I will not answer. You ask more and more complicated questions. At one stage, they will say, oh my God, I don't know. Then you tell them, boss, you do one thing. My office is here, gives my card. Come to my office. In detail, I will see it. Definitely, I will answer your question professionally. Then they will get the signal, oh, if you go to his office, I may have to pay a fee. Okay, I'll call you later. They'll go off. So if you want to avoid, there is a best way. But if you see, I answer all questions. What is there? If you have a little bit of knowledge, you can share. Nothing wrong. Sharing knowledge, after all, is not a mistake. So long as they are not misusing the privilege or wasting your time. After all, sitting in the reception, standing in the queue, what else is there to do? Maybe we learn something from that new. Believe me, many times when clients come to me with the problem, new problems make me read more and more and make me give better solution. So that next time when similar case comes, I know the answer. Practically, I can tell, hey, this case like that, you have to do. So this is what, your exam can only take you that far. Beyond that, that is why we practice. The experience is having value, which is why 3 years articleship they are asking you to do. So that you will learn from your superior, how he handles situation. That is the purpose of articleship. Not to waste your time or to make you, waste your time, but to help you to learn from a senior. Just like, house surgeons, they can't, directly he cannot go and operate, He can't become, because he's qualified MBBS, he can't go and operate. 5th year house surgeoncy. So it will take him 3 years before he qualifies. Properly, they allow him to go and operate or not even operate. Allow him to go and sit in a diagnosis. It will take time. Okay. Chalo, this is just for information. Sorry for wasting your time. So let us see what is saying. No, the proposal not valid. Any member can vote less than that he holds shares. That is, sharehold 15, not Ramja, he can do it. I have answered your question. Why he will do? Baba, God only knows. I am having 1,500 shares. Why the hell I will vote for 800? Why? See, he can. Okay, he can. See, can I cut my little finger? Yes, I can. It is my little finger. I can cut it. But why I will do it? I mean, I'm unable to understand. I'm giving 1,500 shares. Why I will vote for 800 when I'm entitled to 1,500? So this is, I mean, you are asking me, can he do it or not? Answer, he can. But Baba, why? Then if a single person is having a shareholding of 40% or more shareholding, can he appoint proxy? Because if then proxy will have shareholding. Kana, proxy will never have shareholding, ma Aparna ji. Show who is the owner of the share. In these cases, these fellows are the owner. Sushil is not the owner, ma. These fellows are controlling. The Sushil man is only representing them. I think you have not understood proxy at all. See, proxy is not become the owner. He cannot. He is only a representative. So in my example, when I said proxy controls 60%, there is a shareholder who is the owner of that 60%. He is not coming. Instead, the proxy comes. Proxy controls 60% share capital. Again, member also cannot come and control 60%. If the member comes, then proxy has to go. Only member will vote on 60%. Since the member cannot come, only proxy has. So, got it? Can you appoint proxy? Because if you appoint proxy, that property will have shareholding more than 10%. No, you have not understood at all anything. See, point is, if I am having more than 10%, I am a member having more than 10%, then I can appoint a single person as proxy. Got it? Because it's more than 10%, I need not appoint. Suppose I'm holding 40%, I need not appoint 4. I can appoint a single person. For my entire 40, I can appoint a single person. That's all it means. The proxy will not become owner of more than 10% now. Okay, Aparna ji, you have misunderstood. I hope I have clarified. Okay, at the meeting, the proxy will be able to control 40%. That is the example I have given. So this does not mean that the proxy is having more than 10%. The original member is having more than 10%. He has appointed a single proxy. That's all. Thank you, sir. Thank you very much. For Rituraj, thank you very much for your nice words. What if a proxy represents 2 members? And 2 members sent him with 2 different. That is possible. Why not? Why not? See, for example, in this example itself, if Achyut and Anant want him to vote for, Keshav, Kurup, and Narayan Unni Nair want him to vote against, he can vote. Please, proxy is only an agent. Isakaro, you have to do it. You have no business for your own opinion and all. See, that is also possible where we give the proxy, 2-way proxy. That is, if the proxy is given the option, then he can choose whether to vote for or against. But if the member says vote for or against, then proxy has no choice. It's a normal proxy, no choice. Whatever the member says, you have to do. But if it's a 2-way proxy, where proxy has an option, then proxy can decide. Otherwise, no. So if proxy is representing more than one member, he has to obey each and every individual member's decision. But usually it won't happen. Group of people will come together. They will decide uniformly. Since they all cannot go, they will appoint one guy to go and do it. That's how reality will happen. The reality. Rarely you will find 2 contradicting people selecting a single man as a proxy. Okay. I mean, I wish, you will all do reality checks. Your questions are all nice, but practical life is totally different. You should imagine how it will happen in real life. Okay. That's why I'm trying to give you some practical examples of real life people and situations which are real. See, the names are disguised, but the situation is true. Okay. I was there at that meeting and I was the proxy. I was running the process. Okay. So, statutory information regarding proxy in the notice. See, Baba, you are all experts in company law. I am an ordinary Aam Aadmi from Punjab. I don't know anything. I have not studied company law. I don't know section 105. I don't know that I'm entitled to appoint a proxy. I don't know that the proxy need not be a member. Therefore, in order to educate me, the notice calling the meeting should clearly mention in bold letter that a member entitled to attend is entitled to appoint a proxy. Proxy need not be a member. Next time when you see AGM notice, maybe before this class gets over, inshallah, I'll show you the AGM notice. There clearly it will be mentioned. Okay. If default is made in complying with the above provision, every officer of the company who is in default shall be liable to penalty of 5,000 rupees. Now, when the proxy forms are deposited, these can be inspected by any member. Okay. 24 hours before the time fixed for the meeting, anytime the members can. Because when there's a fight between two groups, each group will be interested in verifying the proxy to see whether any forgery is there. So they will compare the signature with the specimen signature, everything. Okay. But today, believe me, all this is becoming a little foolish because most listed companies they are going for e-voting. Okay. Only if a listed company or an unlisted public company or a private company is going to have a physical meeting where voting is going to be done, only then all this will be relevant. Because on e-voting, what's the problem? Member directly can vote on, or a postal ballot directly. Why should I appoint a proxy? I can myself go to the computer, check, over. That's all. Okay. So, but then where there is a proxy and proxies are deposited, members are entitled to deposit during the period beginning 24 hours before the time and ending with the conclusion of the meeting. At any time they can do it. Then later on also, if any forgery is found, they can complain. But notice is to be given of the intention to inspect. Not less than 3 days notice should be given of the intention to inspect so that the company will make necessary arrangements. So, see, a company cannot issue invitations to appoint a proxy, a person or one of the number of persons specified in the invitations. That is, you cannot have so-and-so people appointed as proxy, send invitations. Company cannot do it. Company cannot send a list of invitation. Okay. So such invitations sent to proxies and all will be offense. Penalty of 50,000 rupees. But suppose the member, is asking, I want a list of persons willing to act as proxies. On his request, if I give a list, that is not a problem. But unsolicitedly, I cannot send invitations to people saying you appoint so-and-so as proxy like that. Offense. See, this happens when there is a proxy war. So what happens now? We identify 60 people and say they are our proxies. So we start sending invitations to members saying, hey, please appoint these people as your proxy. That is prohibited. Any officer of the company who issues such invitation shall be liable. But suppose I'm a member. I can approach the other members and I can tell them, please appoint me or please appoint me and these people like that. No problem. Though it says the proxy need not be a member, it is not saying that a proxy should not be a member. Proxy may be a member, but need not be a member. Okay. So I can be a member and also a proxy. I can attend as myself and as proxy for 50 other people. On my own behalf, and 50 other people I can attend. Okay. So in the case of government companies or any other company where central government or state government is a member, the shares will be held in the name of the President of India. So in those cases, the President or Governor may appoint such persons as he thinks fit to act as his representative at any meeting of the company. Okay, so this will be the representative of the Governor or President. For central government, the shareholder will be the President. For state government, it will be the Governor. Now the President or Governor may appoint, because every time President or Governor cannot attend. So they will appoint a senior civil servant to attend. That's his representative. Such person will have the same rights and powers as the President or Governor. So they are the representative of the President or Governor. Now they in turn can appoint a proxy or they have the right to vote on postal ballot. So they can appoint a proxy. So Governor appoints a representative. The representative can appoint a proxy. Okay. Now, a body corporate, whether a company or not, may be a member or creditor or debenture. In such cases, such body corporate may appoint such person as it thinks fit to act as its representative at any meeting of the company. Now, this is something that's always confused me because there they say where a body corporate is appointing a proxy, it should be signed by the representative. Here they say body corporate may appoint somebody as a representative. Now, the point is the representative appointed by the company through a resolution of the board shall have the same rights as a member, which means that representative can appoint a proxy. Got it? So there seems to be a conflict between 105 and 113. So my humble view is that 113 will prevail. Meaning, if you are a company or a body corporate, okay, and you are a member of a company or a creditor or debenture holder, if there is a meeting of members, company cannot attend because company is an artificial person. So the board of directors of the company will authorize one person to be the representative. That representative will have the same rights and powers as the company. So now that representative can appoint a proxy. This is what they are trying to say here. If the appointer is a body corporate under his seal or signed by an officer, I think that's what it means. Suppose a body corporate wants to appoint a proxy, then it can either do so under its seal or it can authorize somebody, and that authorized representative can appoint a proxy. I think that's what it means here. Okay. So we are making not bad time, but I wish we had done more. It's okay, so long as you're understanding. Sir, one representative of two companies, whether vote will be counted as two votes? See, one representative of two companies, come, it will be counted as two votes. Again, it will not be counted as two votes. Again, you are confusing. Nagaraju. Think about it. I am representing the company. I am representing A Limited, I am representing B Limited. I am the representative. I am attending on behalf of A Limited and B Limited. A Limited is having 5 lakh shares. B Limited is having 7 lakh shares. Together, I am controlling how many votes? Not 1 vote or 2 votes. I am controlling 7 lakh votes. Please understand this principle. That is when you will be clear. So when I am appointed by 2 companies, I can be. I am representing. I am not coming for 2 companies alone. I am controlling 7 lakh shares, which could be easily 40% of the total voting power. I'm sitting there and watching, single man. See, this is the power of corporate dynamics. Please understand the reality. Then you will understand the topic very easily. So your question of counted as 2 votes is not correct. Will the shares of these 2 companies be counted? Yes. When I vote, I will vote for A Limited 5 lakh, B Limited 7 lakhs. 2 proxy sheets will be there. 2 polling sheets will be there. Here also I will vote. There also I will vote. Straight away, sir. In fact, intelligent chairman will simply see proxies. How many proxies are there? If there are more than 50%, ordinary resolution surely passed. Fellows will definitely. So he will easily ask, hey, are you going to vote for or against? So say, sir, if you're going to remove him, we are going to vote against. 60% against, 40% for. End of matter. Yeah. Why go through the process? Okay. They will abandon the agenda item and go. Like, these are all things that happen. Sir, Harish Babu, you are going to become a chartered accountant. So your life is going to be involved in money matters. So don't say money matters. Money matters. Money matters. And you are going to be the man who is going to be engaged in money matters. So you should have thorough awareness of what you are doing. Okay? That is, even today with all this, if it comes to financial matters, chartered accountant is the man who will decide, because we are seen as authority on finance and accounting, right? Which includes knowledge of law also. Don't think law is a subject where I don't have to know. No, because it is closely intertwined with financial matters. Correct? Well said. Chalo, methods of voting. Now there are 4 main methods of voting. Voting by show of hands. Okay, just lifting the hand. It is possible when the number of members is less. If too many members are there, how to count? You saw the Reliance meeting photo, na? How will they count? Yeah. So voting by a show of hands is just there. Voting on a poll, where there will be a polling sheet. On that sheet, each item of agenda will be printed. Against that, there will be 2 boxes, for, against. So you have to tick. On top of that, the name of the member, registered folio number or whatever distinctive number of shares held by him will be there. That's all. Now the polling sheets will be distributed. Then they'll be given a secret place to vote. They will all go there. Put tick. So once you put tick against for, if you are holding 700 shares for, then 700 votes for. Finally, all those polling sheets will be folded, put in the box, then the box will be sealed, then the scrutineer will take it. He has some time, we'll see that rule also. Then he will open the box, count the votes, announce the result. So 700, suppose somebody is holding 700, polling sheet, they will count it as 700 votes. Like that. Voting through electronic means is simply the same process will be happening through electronic. Instead of paper, you will go through a URL link to the site. There, that same polling sheet will be displayed on the screen or on your mobile phone. All you need to do is click for, then submit. You will be using a user ID and password which is given by the company, which is linked to your folio, to your membership folio, which means automatically the system will know if it is coming through this user ID password, 800 votes. It will keep track, check. But only the scrutineer can see. Nobody else can see the. Finally, the scrutineer will use his user ID and password to open the file, and the result will be there. He'll announce it. Got it? This is simply voting through electronic. Voting through postal ballot is where the same sheet is sent by post to you along with the self-addressed stamped envelope. You are given time to think, then tick, then put it in the cover, paste it, stick it, put it in the post. It will come to me. Same, I'll put it in a box. Scrutineer will control it. Scrutineer will go and make an announcement. So the principle is the same in all these three. Voting on poll, voting through electronic means voting through. In these two cases, in this and this case, there will be a scrutineer. Even here, all the three cases, there will be a scrutineer who will be a man of reputation. Okay. Once you understand the basic principle, now we can actually skip a lot here. Can skip a lot here and go. Okay. Now, at any general meeting, a resolution put to vote at the meeting shall be decided on show of hands, unless poll is demanded. Poll is demanded by a member or proxy, or the voting is carried out electronically. So, if it is e-voting, then no question of show of hands. Okay, even those members who attend in person or proxy at the meeting should vote only on poll. No question of show of hands. Okay, then the physical meeting votes are cast. Those sheets will be taken. The e-voting will be taken. In many cases, what they do, they give separate booths where members who attend in person, if they have not already voted, they can simply go to the electronic booth and enter their vote and come. That's it. That will also be included in the total. Okay. Now, at the end of this, the chairman will declare the result. Now, suppose there is a meeting. Initially, there are about 15 people. Voting is by show of hands. Now, the chairman will announce the result now. Okay. Whatever he announces to be final will be the final. Thereafter, no question. But before the chairman announces the result, if a poll is demanded, then no, that result is gone. Okay. So a declaration of the by the chairman of the meeting of passing of resolution shall be conclusive evidence. But if there is a demand for poll before or on declaration of the result of the voting, that is, voting has been by show of hands, even as the hands are going up, a member or a proxy can stand up and say, Mr. Chairman, I demand a poll. Or the chairman announces the result. The minute the result is announced, I say, Chairman, this is all, I don't agree. I demand a poll. That's all. Then a poll shall be taken. So the chairman may, on his own motion, and shall do so on a demand made by the requisite number of members. Now, what is the requisite number of members? Members present in person or by proxy, both proxy and person, having not less than 1/10 of the total voting power, on which an aggregate sum of not less than 5 lakh or such higher amount has been paid. So they should hold not less than 1/10 of the total voting power, or they should hold shares on which 5 lakh rupees is 4. As of now, it is 5 lakh. So I may be having 1/10 of the total voting power. It may not be 5 lakhs, but still, if I am holding 1/10, I can demand a poll. I may be holding 5 lakh worth of paid up capital, but it may not be equal to 1/10. Even then, I can. So whichever is less. So 1/10 of the total voting power or 5 lakh. See, suppose the company is having 5 lakh shares. 5 lakh shares. I am having 1 lakh shares. Why 1 lakh? I am having 55,000 shares. Then I can demand a poll. Because 5 lakh divided by 10 is 50,000. I am holding 55. So I am having 1/10. Or I may be having shares on which 5 lakh rupees is paid up. But that may not be 1/10. Still, I can demand it. Okay. In the case of other companies, obviously not having share capital, etc., any member present in person or proxy having not less than 1/10 of the total voting power. See, let's say there's a Section 8 company, no share capital. It has 20 members. Then 2 members, 1/10, can demand a poll. Because voting power is 10. Out of that, 1/10, 2. 2 or above can demand a poll. Once a poll is demanded, the chairman shall take. But the poll can be taken at an adjourned meeting also. Because I need to prepare polling sheet. I didn't come prepared. So the chairman may adjourn the meeting for taking of poll. But on 2 matters, the chairman cannot adjourn. Means where there's a poll demanded on any question other than adjournment of the meeting. See, suppose the question is, we should adjourn. Now the chairman says, let's have a poll. We'll take it 2 days later. Hey, come on. The question was whether to adjourn or not. You're saying we'll have a poll. And you're saying we'll have it 2 days later. That amounts to adjournment, Baba. The question is whether to adjourn or not. So the members are saying, let us continue. We want to finish this matter now. But you are saying, let's have it 2 days later. So a poll on adjournment should be taken forthwith. Similarly, poll on appointment of chairman should be taken forthwith. See, meeting opens. Mr. Donkey is appointed as chairman. Now, one member says, hey, Donkey, I want poll. Whether on election of chairman, let's have a poll. Now, Donkey immediately says, absolutely, we'll have a poll. We'll have it, say, 2 days later. Hey, then Donkey will continue as chairman for 2 days. No. Once the question of chairman appointment is there, poll shall be taken forthwith. Similarly, poll on adjournment question should be taken forthwith. Any other matter can be adjourned for taking the poll not later than 48 hours. So within 48 hours, you have to have a meeting. So even then 48 hours. You cannot go beyond 48 hours. Okay. Okay. But you can be 24 hours or 48, maximum 48 hours. Right. Or whatever. Now, the demand for a poll may be withdrawn at any time by the persons who made the demand. See, I make a demand for poll, then I can withdraw it also. No problem. Chairman of the meeting is a person who manages and controls the meeting. He has complete authority. On conclusion of the meeting, he has to ensure that the minutes of the meeting have been correctly recorded. Question was asked whether the chairman of the meeting should be a member. Answer is no. See, sometimes the chairman of the board, who may not be a member, will be the chairman of the meeting. In which case, he need not be a member. Okay? No such rule is there. But normally, you see what happens, the voting will happen from amongst the members. It so happens. So chairman has prima facie authority to decide all questions, including disciplinary issues, everything, and his decision is final unless he is being partial or he is being wantedly. Unless the articles provide otherwise, the members personally present at the meeting shall elect one of themselves to be chairman. So, this is the general rule. Only one of the members can be elected as chairman. But the articles can say that the chairman of the board shall be the chairman of the meeting. The chairman of the board may be a director and he may not be a member. Still, he can be chairman. But if the articles do not provide like that, then the law says the members personally present shall elect one of themselves to be the chairman. So proxy cannot become a chairman. If he is a member, he can be. If he is not a member, he cannot be. Okay. But if the articles provide, he can. So the articles can provide otherwise. We already saw that poll for election of chairman should be taken forthwith. Okay. So Once a chairman is elected on voting by show of hands, that's it. If there's a poll demand, that chairman will continue, take the poll, announce the result of the poll. Either he will continue or the new chairman will continue. Okay. If you allow me to go for another 2 minutes, I can finish this. I'm sorry. And I can. One sec. I will. Not bad. We have come quite a long distance. It's good. If you want to stop here also, let's go on to the next. In the next session, we will start this. Let me see any questions are there. Voting. I'm voting to serve by hand for best teacher of. Okay, thank you, madam. So that's so nice of you. Because other views are also expressed in the last class. So in Tamil, we have a famous Poongundranar, Kaniyan Poongundranar. Let me end with this quotation. You will find that he says, Yadum ure yavarum kelir, idum nandrum piradaravara. So everybody is my relative. Every land is my native place. Yadum ure yavarum kelir, idum nandrum piradaravara. Good and bad does not come from outside. So absolutely, I'm delighted when I get such good comments from students. More than that, when I'll be very delighted, my dear friends, when I hear that you have passed the exam. Okay? When I hear that Neha Harge has passed the exam, that day I'll be very, very happy to know about it. That will give me the greatest joy. So let us be there. And thank you very much. Notes will be, Harish Babu, listen to me, watch my mouth. Notes will be uploaded after the last session on this topic. Watch my mouth. Notes will be uploaded on the last session. Before that, no. And it will not be sent to you. It will be uploaded in the portal from where you can download it. Have you got it, Ji? Harish Babu Ji? From which part of Tamil, SR do you come from? Thank you, Ramja. Thank you for raising your hand. So nice of you. So, thank you for being a great participant. Let's hope to complete this topic well in time because I'm going behind schedule. Anyway, so class over. All the best. Have a great weekend. Productive weekend. Studies. Okay? Bye.